And we are recording. Chair Schmidt, would you like to introduce the meeting?
I will ask you, Cheryl.
All right.
You could do that, please. Thank you.
5:42 p.m. This is the Sunshine Ordinance Task Force Complaint Committee hearing. It is a remote hearing. Listen and public call-in phone number 415-906-4659. Meeting ID 948-461-600#. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Today's date is October 19. Roll call. Member Stein.
Here.
Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. We have a quorum. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely, via Microsoft Teams, and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. That's CHERYL.LEGER@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. I will repeat the meeting call-in number and meeting ID. Call-in number 415-906-4659. Meeting ID 948-461-600#. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, shall I read meeting decorum or would you like to?
Sure, I'll do it this time. Meeting decorum, any member of the Sunshine Ordinance Task Force may call for decorum. Call for decorum. Due to disorderly conduct of meeting participants, persons who engage in threatening and or menacing behavior may be asked to leave.
Shall I read item number 1, sir?
Yes, please.
Call to order, roll call, and agenda changes. We have had roll call. Call to order was at 5:41 p.m. I am not aware of any agenda changes.
And I am also not aware of any agenda changes. Is anyone else?
No.
Okay. So I think we're clear on number 1. We can go to 2.
Item number 2, approval of the September 21, 2021 Complaint Committee meeting minutes. Do either of you have changes you would like to suggest? I have a copy of the minutes right here.
This is Member Stein. I don't have any suggestions.
No changes. Chair Schmidt.
Okay. Let me write that down. No changes. Shall we call for, do we want to make a motion to approve the minutes?
Move to approve. Sorry.
This is Member Stein. I'll make a motion to approve the minutes.
Second.
Shall we open public comment?
Yes, please.
This is public comment on the motion to approve the September minutes for the complaint committee. Do we have public commenters? This is
Any
public.
commenters on the minutes? Looks like there are none.
Okay. I will note the record. Let's take a vote. Member Stein.
Aye.
Member Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Moved by Member Stein, second by Chair Schmidt to approve the September 21, 2021 committee minutes.
And Ms. Lejay, whenever you're ready, we can move to number 3, public comment.
Okay. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Okay, is there anyone here who wants to speak at general public comment for this meeting? *6 to unmute, is that correct, Ms. Lejay?
Yes, it is.
This might be a landmark. We have nobody for general public comment. Last call. Okay. Looks like we might as well go on to number 4.
Item number 4, file number 21094, complaint filed by William Peters against the Police Commission for allegedly violating Administrative Code Section 67.1A-1, 6721, 6724H, California Government Code Section 54956.9 by failing to respond to a request for public records in a timely and or complete manner. I guess I have notes in here that this is regarding a closed session audio recording.
Yes, of March 6, 2019. Okay, since this is our first case, I will just clarify that this is a complaint committee meeting where we do not make a decision on the merits in these cases, but we do a preliminary review and we screen for certain aspects of the case. Some cases will get into deeper than others, but our primary function here today is to see if a case may not be ready for the task force, or if it is ready for the full task force, to determine if a matter does involve public records, and there's also what's called a determination of jurisdiction. Those are in some cases we will make a recommendation. So with matter number 4, I'd like to ask first, is the complainant present? And that's Mr. Peters.
Yes, I'm here.
Okay, great, thank you. And is there someone here on behalf of the Police Commission?
Yes, Sergeant Youngblood for the Police Commission.
Sergeant Youngblood, thank you. Okay, we will start out with, we will, we'll give you 5 minutes each to present. We have had the documents, we've looked at the documents in the file, but you can also present anything you want to present verbally in addition. starting with Mr. Peters. When Cheryl's ready, your time will start.
Mr. Peters, are you ready to begin?
Yes, I am, Cheryl.
Go ahead, sir.
Okay. The following is an audio clip of a police commission closed session hearing. After a male voice says he is, there is an anomaly. It is at this anomaly where both the audio and the transcript have been altered. Please listen. Well, please start over. Sorry. I just played it while I was waiting, but well, I'll have to go on. Basically, it shows where the anomaly is. I'd like to be able to play it. It's only 5 or 6 seconds long, but I can't get it up here, so. But we'll go on. Additionally, the recordings were requested and received by a public records request. This is documented on page 3032 of the evidence packet. The commission falsely stated that there's been some type of secretive phone conversation that took place where there was a verbal agreement made between these records would be released as personnel records requests. That is a lie. The police commission's additionally, the recordings were requested and received by public records request. I just finished that. The police commission's most recent resolution determining not to release the public records claims that they have an attorney-client privilege that they refuse to waive in the closed session deliberations. The Brown Act does not, in fact, permit closed sessions for the purpose of attorney-client communications on its own, except regarding litigation. Roberts versus City of Palmdale, 1993, 5, California 4363. Also see the Open and Public 5 by League of California Cities, which is on page 36 of the evidence. Additionally, evidence revealed in Government Code Section 54956.9 states in relevant part, nothing in this chapter shall be construed to prevent a legislative body of a local agency based on advice of its legal counsel from holding a closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning more than those matters would prejudice the position of the local agency in the litigation. For purposes of this chapter, all expressions of the lawyer-client privilege other than those provided in this section are hereby abrogated. This section is the exclusive expression of the lawyer-client privilege for purposes of conducting closed session meetings pursuant to this chapter. This evidence further supports that the requested documents must be released. And note that the Police Commission has not cited any section of the Brown Act for a proposition to have attorney-client privilege closed sessions outside of litigation matters. Instead, closed sessions have to be held under a specific exemption to open session permitted by the Brown Act. More importantly, the Commission did not publicly state the basis for the closed session as a litigation matter. Therefore, the records requested are disposable. See the evidence, open and public B, page 43, second paragraph, which reads, before holding a closed session under the pending litigation exception, the legislative body must publicly state that the basis for the closed session by identifying one of the following 3 types of matters: existing litigation, anticipated exposure of litigation, or anticipated initiation of litigation. In this case, it was a personal closed session citation that was used, not the litigation closed session. And because it was a personnel matter, not a litigation matter, Penal Code 832.7B and SB 1421 explicitly make this recording publicly disposable. In fact, the Sunshine Ordinance demands certain boilerplate language to be used to justify each closed session. SOTF should examine the evidence contained in the agenda, in the original agenda item, to realize that it was not an attorney-client privilege litigation closed session, but instead a personnel closed session.
Mr. Peters, your
matters-
time is up.
Thank you, Mr. Peters.
Thank you.
Before we go to the respondent, I have one question for Mr. Peters, which is, there's kind of a critical item that I need from you right now, which is, what is the content of the actual missing information that you are, what was the hearing about that your claim is about?
The hearing was in the part of the meeting on March 6th, where the tape just goes blank. It's in the middle of one conversation, and then we don't know for sure how long it went thereafter, but then it starts in the middle of a conversation, and there's a piece of that audio tape missing.
Okay, you said it's a personnel matter. Who's the person who this was the subject of?
Okay, I now have this so it will open. This is actually.
Who is this about?
Pardon?
Who was this hearing about?
Christopher Coors.
Okay, thank you.
You're welcome. And I did, my computer just decided to work, so I played a small portion of that.
I need to hear from Mr. Youngblood at this time, and whenever Cheryl's ready, we can go on to that.
Sergeant Youngblood, are you ready?
Yes, ma'am.
Go ahead, sir.
So this was a public records request that was received by the Police Commission asking for a recording from a hearing of a former officer, Chris Coors' disciplinary hearing. This is kind of a repeat from a Sunshine Task Force complaint that Mr. Coors himself brought before the Sunshine Task Force, in which the Police Commission was found not to have violated any statutes or laws when we did not release the deliberation portion of the recording to Mr. Coors, who the recording is about. We released this information to Mr. Coors. The hearing recordings, but not the deliberations, were released to Mr. Coors as a former police officer requesting his personnel records, not as a public records request. That phone call with Mr. Coors did take place. The recording that is being played is the exact same recording that Mr. Coors played at the Sunshine Task Force previously. The reason that these are not released is because they are a personnel matter, and per 832.7 APC, police personnel records shall be confidential. We did quote to this requester that the Police Commission, when they go into closed session, that they do have a privilege to go into closed session and deliberate on personnel matters per California Government Code 54963, 54957, 6254K, as well as San Francisco Administrative Code 67.10. These records are not SB 1421. SB 1421 records must fall within 4 categories. This public records request meets none of them. Therefore, they are not SB 1421. They are personnel records, and therefore they are not public records. And that is it.
Okay, thank you. So at this time, the members of the committee may have questions. And I will first ask Member Stein if she has any questions at this time.
Yeah, I don't think that I do.
Okay. I'll ask Mr. Peters. Mr. Peters, were you present for any of the committee or task force hearings where Mr. Kors presented his case?
Yes, I was.
Okay. Okay. Okay, that's, I don't think I have anything further on this. Yeah, no more questions from me. So now we can talk and figure out what shall we do with this case today as a committee. And certainly there's one thing here that jumps out at me is pretty clear. But any thoughts, Member Stein?
Yeah, so I feel like this case is a duplicate request for information that has been heard by the full task force, and also a request for reconsideration was heard by the full task force on this exact same request. And I understand that a different party is making it now, but this is a party that also seems connected to the original party. You know, we have, I mean, I'm just looking at our public hearing procedures. We have under C1, we say that we do not hear duplicate complaints by the same complainant. And I think maybe it's not the exact same complainant, but it's somebody who was involved in that original complaint, wrote letters in support of it, you know, wrote analysis of it and so on. And then Section D1 of our procedures also says that we hear only one request for reconsideration, which we also have already heard. So, you know, my thinking is this is a duplicate complaint or a request for reconsideration of a complaint that's already been made by a party connected to the original party. And for that reason, I don't think it should be reheard or heard again by the full task force.
I'm sorry. It's my turn. You think we should?
I'm sorry.
Yeah. Member Stein, you think we should just move it on and tell the task force what's going on here? Or do you think we should not?
I think it's against our procedures to hear the same complaint again. It would essentially be a third bite of the apple now, because we've had the request, we've had the request for reconsideration, and now this is the exact same request with no new information, no new arguments, and, you know, put in by a party connected to the original party who placed the request. So I don't feel that it's the right appropriate use of the task force time to reconsider this for a third time.
I'm in agreement. I'm not sure. I don't see that there's anything that is new. This thing was it was aired out before, and so I guess maybe I'll just make the motion and say that we will go ahead and have this heard by the full task force with the specific clarification that it appears it is exactly the same case as was brought by Mr. Kors, except that it's brought by another individual who's not Mr. Kors, and so it doesn't involve this individual's personnel records.
Yeah, I mean, I would almost want to say that by our own policy, we shouldn't be forwarding it to the full task force. But,
Okay.
But if you want to, I mean, I just don't know how it's done.
Yeah, I think that the rules are, I don't quite understand what rule we could use to dispose of it any other way at this time.
Okay.
I think the task force's existing rules, which were, who knows how long they've been in place, don't seem to give us another way to deal with this. And so I don't know if we can do anything other than just pass it along with a very specific determination that the two of us have been able to make here today.
Okay.
Before we go ahead, Victor?
See what Victor says.
Yeah.
Yes.
My thought is to table
the committee is not able to table a matter, only the full task force has it. This is probably an issue where we probably should have intervened when this apparent duplicate filing was filed, because we don't want to go through the double jeopardy process, having to hear the same. We can't put a respondent in double jeopardy where they have to respond to the complaint multiple times. But I think you are correct. We should just send it up with the recommendation to close the file, as the committee has already heard the matter and made a decision.
Yeah, I think in our motion we should just point out that we've heard the matter and we've heard the request for reconsideration on the same matter.
Let's amend the motion exactly as Member Stein has stated, to add the mention of the request for reconsideration. But I believe we do need to send it to the task force just to.
Okay.
And I will also note that this does seem like it's a situation that frustrates me personally in the way that these committees are set up, because if we're here to look at questions of whether it's like we just have to answer yes to every case according to the rules. And so I have some question as to what exactly our effectiveness is here. But that's something that is just a personal observation. So that's the motion.
So I will second it.
Okay. All right, let me just make sure I've got it. Moved by Chair Schmidt, second by Member Stein, to have the matter heard before the Sunshine Task Force with the specific clarification that it appears to be the exact same case as was brought by Mr. Kors, but is now brought by another individual and does not refer brought by another individual.
Well, Cheryl, can I make it a little more? What I had said was that it's just to use the language that we've used in our own policy, that it appears to be a duplicate request for information that has been heard by the full task force already, and a request for reconsideration that was also heard by the full task force. Although it is being made by a different party, that party also seemed connected, or was also present and contributing well, I'm not sure how to put this, but it's a related party to the original requester.
Okay.
I don't know what the relationship is, but is related, like has already given input on this case.
Okay. I hate to say this, but you were saying that a little fast, so I couldn't type it all. Is there any way you could repeat that?
Which part? The whole thing?
Yeah, the whole motion. Dean is moving. You're second.
You're taking it forward.
I'm sorry.
Let me take a shot at it.
Send it to the full task force with the note that it seems to be a duplicate request for information already heard by the task force, and request for reconsideration also already heard by the task force, although it's being made by a different but related party to the original request.
And yes, that is the motion.
Move to refer the matter to the task force, that it seems to be a duplicate request for information already heard by the task force, and request for consideration already heard by the task force.
That's reconsideration.
Reconsideration.
Reconsideration, yeah, reconsideration already heard by the task force, although made by the original party to the request.
No, sorry. It's a different party that's making this.
I know.
Oh, okay. I thought you said the same party.
Well, made by a different party other than the original request.
But a related party. Related should be there, because it's not someone who's come along, knows nothing about the previous request, and is now making this request. It's someone who has given their input already. And the reason I stated it that way is that our policy says that we don't hear duplicate complaints by the same complainant. And you could say that technically this is a different complainant, but it's a related complainant, and it essentially is the same complaint.
Okay.
I'm just explaining. Like, you don't have to...
She's explaining, but I think Cheryl, you had it squared away there.
All right. Shall we open it up for public comment?
Yes, please.
I'd like to make a public comment.
We have one public commenter. Shall we call you speaker number one?
Yeah, that's fine.
Yes, and is there anyone else who would like to comment on this matter in public comment, but that would not include the parties to the case? So we have one. All right, so whenever you're ready, Cheryl, let's hear from that person.
Sir, are you ready?
Yeah.
You may begin.
By law, these records are public records. And if you look at the law, it specifically states that this was personnel matter, not a litigation matter. So it's disclosable. It was requested as a public records request, and it was received as a public records request, and that is documented. On top of that, the fact that there's an anomaly in the tape, if that's not enough to bring transparency to this matter, then what is? By law, the Sunshine Ordinance Task Force has a higher degree of transparency than even the California Public Records Act. Transparency is a good thing We need this. It keeps everyone honest, keeps everyone ethical. Without it, things can go downhill really fast. The public needs transparency in this matter. Thank you.
All right, thank you. And I believe that was the one public comment on the matter. So Cheryl, whenever you're ready, I think we can have a vote on this.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, second by Member Stein, to refer the matter to the Sunshine Task Force, that it seems to be a duplicate request for information already heard by the task force, and a duplicate request, and the request for consideration already heard by the task force, although being made by a related party to the original request. Did I get that, Laura?
Yeah, just reconsideration, request for reconsideration.
That's what I did.
Okay, you wrote that, I guess, but you said consideration.
Oh, sorry. No, I wrote it. Sorry.
Okay.
Yeah. Okay.
Good. Okay. Whenever, Ms. Leger, whenever you're ready, we can move to the next item.
Item number 5, file number 21114, Monica Price and the First Amendment Coalition against the Police Department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and complete manner.
All right. Let's go ahead. Each of the parties will have 5 minutes. We have already been looking at your documentation that you've submitted, but let's go ahead and first I'll ask, is anybody here or who is here for the petitioner complainant?
Monica Price with the First Amendment Coalition.
Okay, great. And for the respondent, the police department?
Lieutenant Para.
Lieutenant Para, thank you. Okay, so let's start with Ms. Price. When Cheryl's ready, you have 5 minutes.
Ms. Price, are you ready?
Yes, I'm ready.
Go ahead, ma'am.
Okay. Hello. Thank you for your time today. My name is Monica Price, and I'm a legal fellow with the First Amendment Coalition. We're a nonprofit focused on government transparency and accountability. We encountered some issues with a recent request for records related to the in-custody death of Christopher Clement. We requested records from the San Francisco Police Department on August 3rd, 2021. And on August 20th, 2021, SFPD responded that they have determined that there are no responsive records under Senate Bill 1421. SFPD, though, they do have responsive records, and Senate Bill 1421 requires SFPD to release those records to the public. Mr. Clement passed away after an interaction with the San Francisco police officers on January 5th, 2019 at California Pacific Medical Center. Mr. Clement was forcibly removed from the hospital. He was placed in restraints, and he subsequently suffered a heart attack and died as a result of that restraint. If you may recall, this was reported in the Chronicle and other news organizations. Mr. Clement, yes, he was under the influence, but he went into cardiac arrest shortly after the police restrained him. Furthermore, the cause of death released by the San Francisco medical examiner says cardiopulmonary complications of methamphetamine and cannabinoid intoxication with law enforcement restraint. And what this means is that the medical examiner determined that Mr. Clement's heart and lungs were not able to function correctly as a result of drug use and the law enforcement restraint. But somehow when we asked for records, the police department said that they have no records related to what happened that day. And this really doesn't make sense. pretty much impossible that they do not have any records when someone died in their custody. We know that these records exist. And there are two separate legal requirements that require the release of these records. There is the San Francisco Sunshine Ordinance, Administrative Code Section 67.24D, states that the chief of police is encouraged to cooperate with the public by allowing access to records of investigations, arrests, and other law enforcement activity. Once the district attorney or a court determines that there will be no prosecution, these records shall be disclosed to the public, is what the Sunshine Ordinance says. And the district attorney in this case confirmed that they are not seeking prosecution against the officers on January 21st, 2021. So we have that confirmation, and that's attached to our complaint as attachment 3. The police department's letter denying access says that there are no responsive records under Senate Bill 1421. This law was passed in 2018 in order to allow public access to police investigation records, precisely the type of records that we requested here. Senate Bill 1421 requires the release of records related to uses of force resulting in great bodily injury or death. Again, Mr. Clement's death was a result of police use of force, among other causes, but that is one of the causes. And all of the records of this incident are disclosable under Senate Bill 1421, codified as Penal Code Section 832.7. To date, I have not received any records from the San Francisco Police Department. And I believe this committee requested a comment from SFPD, but I haven't received any comment from them related to this complaint. I'm not sure if this committee received a response either. But part of our mission really at the First Amendment Coalition is to ensure that the public is able to access public records. This transparency is mandated by the Sunshine Ordinance, Public Records Act, and transparency is really essential in order for the public to trust that the government is acting for their best interests. The public has a right to know how the San Francisco Police Department investigates their own when it comes to deaths in police custody, and the public has a right to know about the investigation into the death of Christopher Clement. And I'm finished.
All right, thank you.
Thank you.
Now we can hear from Officer Pera when Cheryl's ready.
Lieutenant Pera, are you ready?
I am.
Go ahead, sir.
Okay, the San Francisco Police Department, we disagree that we allegedly violated Administrative Code Section 67.21 by failing to respond to a public records request in a timely and complete manner. It was filed by the complainant, Monica Price, of the First Amendment Coalition against the San Francisco Police Department. My record showed that we received the request on August 10th, and then we responded with a statement, with an email on August 20th, so 10 days later. Regarding the Senate Bill 1421, as they discussed, the complainant requested records, including all audio and video related to the death of Mr. Christopher Clement, who died on January 7th, 2019, after police interacted with this individual. So the San Francisco, or I should say on September 30th of 2018, former Governor Brown signed into law Senate Bill 1421, which effectively in January 1st, 2019 took effect, and it amended Section 832.7 to create additional exceptions to the confidentiality for police officers' personnel records, thus making available to the public a broad range of records that previously could not be disclosed. So these new exemptions related to the specific incident or termination allow the public now to release reports, investigations, or findings regarding an officer discharging a firearm. So we didn't have that here. The report, investigation, and findings regarding officers' use of force that resulted in death or great bodily injury. I'll get into talking about how that was investigated, and they didn't find there was any merit to that. A sustained finding that an officer engaged in sexual assault, that doesn't apply to this, and a sustained finding that officers were dishonest, directly related to the reporting of investigation, that doesn't apply to this. So we have an independent investigative bureau, the IIB. It's part of the DA's office. It is an independent unit that investigates these incidents. And in this case, we're talking about use of force. So all officers involved shootings and custodies, they also investigate all excessive uses of force, like I said. And they did their investigation, and the IBA completed an investigation of the requested incident on January 2021, concluded there was no evidence that Mr. Clement death was a direct result of force by the the San Francisco Police Department. As this incident request by complainant did not fall into the 4 categories of to disclose under Senate Bill 1421, SFPD notified the complainant that it had no responsive documents, can't release it. Furthermore, California Government Code 62054, the complainant alleges that request files should be released pursuant to this section, subsection F4, release of video and audio recordings that relate to a critical incident. California Government Code Section 6254 F4 subsection 6 defines a critical incident as an incident involving the discharge of a firearm at a person by a police officer or custodian officer, an incident in which the use of force by the police officer or custody officer against the person resulted in death or great bodily injury. This incident was determined not to be a critical incident, as the use of force by the police officer did not result in death and great bodily injury due to their actions, as it was concluded in the investigation by IIB. We supplied the response letter here, and we also have the District Attorney Independent Investigation Report dated January 21st, 2021 regarding this. That's all I have.
All right, thank you.
Thank you.
Okay, so now is the time that members of the committee may have questions for the 2 parties. Anything, Member Stein?
I had a question for the plaintiff, which is or the petitioner, which was, how was this records request submitted? Because there's a dispute over the timing. I saw the request in the packet was dated August 3rd, but the police department says that they didn't receive it until August 10th. How is it submitted?
This was mailed, and I'm located in San Francisco.
Okay. I think that was my only question.
Okay, Chair Schmidt, I have a couple questions for Lieutenant Para. In your response to the request, you said you phrased your response in a certain way where you said we have no responsive records under SB 1421. I want to pull that apart a little bit. If you just look at the request made by Ms. Price and the First Amendment Coalition, there are records that would come within the scope of what was asked for. Isn't that correct?
Well, there are records, yeah.
Okay, and so what you're saying, and exemptions are certainly a big part of what we look at here, but you're saying that anything that does exist out there, you feel that you're justified in not producing. Is that accurate?
Yeah, we can't respond. We have no records that we can respond to their request. Okay,
and that includes the any kind of audio, video. Is that?
Yeah, it wouldn't be under 1421. This doesn't fall into that, so we could not release it. So part of that the state bill 1421. Those are the exceptions. Those 4 ones are the only ones, and it didn't fit any of those criteria.
Now, when you wrote your response to the Sunshine Task Force, and you said that you had that these records couldn't be produced because the DA had made a determination of no, let's call it not a direct result. Did you take into consideration the report from the medical examiner that said that the I'm sorry, I'm going to find it here again. Okay.
I can read it to you if you want.
Yeah, go ahead. Go ahead.
The cause of death was determined to be cardiopulmonary complications of methamphetamine and cannabinoid intoxication with law enforcement restraint.
Okay, so Lieutenant Parra, did you take that into consideration, that document, when you submitted your response to the task force?
No, I only look at what the IIB did. So they would take that into consideration.
Okay.
So I don't do the investigation. I'm just, the final findings is what I go by.
Yeah.
So I can't second guess IIB. I'm not going to say, well, they said this. You know what I'm saying? So I defer to them.
And their job is not to make a determination of how to apply the Public Records Act or the code sections that we've talked about. That's your job, right? To determine what needs to be produced.
Yeah, that's true, but I can only reproduce what based on what they're. So let's just spin it around. Let's just say that they did say that. Then yes, I would produce it.
Okay.
Let's spin it around and say that the medical examiner said the opposite, and they said that. I would still produce it. I would produce it because it would be a violation of 1421. So.
And what's your understanding of what that independent investigation? What is the purpose of that? Is it to determine whether there should be any type of criminal charges brought against the involved officers?
Yes, it's they look into it in a criminal matter.
Okay, got it. Okay, I don't. Thank you, Lieutenant Parra. I don't have any further questions for you at this time.
Okay, thank you.
So unless you have anything further, we could go ahead and deliberate on what we want to do with this.
Okay. I don't have further questions. This is Member Stein.
Okay. Now, let me just say that the thing that sticks in my mind about this is since I'm an attorney, we spend in school countless weeks studying all the different theories of causation. And the wording in these different documents does differ slightly. And what I'm seeing here is really a question of legal causation or proximate causation. It's sort of like in a tort case, although I know this is not a tort case. But when I look at the medical examiner's report, I see that my reading of that is that the medical examiner says that there's two types of causes to what happened here. It doesn't subordinate one to the other. It seems to indicate that these two causes jointly were involved in the death. And I know, I do take into consideration the decision of the decision not to prosecute and their decision on causation. So I don't think that this is something where it's clearly obvious where we fit in terms of the state statutes on what needs to be produced. But I believe that if we didn't have that language in the medical examiner's report, I would be much more on the fence on this thing. But because that's there, I think we do have a factual question that needs to be resolved by the task force. Member Stein?
Yeah, I understand what you're saying. The way I read it was slightly different, which is that, I think there's a question about SB 1421, which, clearly removes some exemptions from the CPRA, right? And therefore from the sunshine, what the Sunshine Ordinance looks at. When there's a when there's a use of force resulting in bodily injury or death. It's not in the wording of SB 1421 that has to be the main cause or that has to be the direct cause. And it seems like the coroner's report is saying that it's a contributory cause, right? So I don't think that the standards for judging whether there was criminal misconduct is necessarily what the application of SB 1421 would hinge on. So I feel like there's an important matter of policy for the SOTF to think about, which is whether it believes that public access to records related to the use of force exists only if the force is direct and presumably the sole cause of death or bodily injury, or whether it exists when the use of force is among the factors resulting in injury or death. And so I think for me, it's an important matter of policy. And because our mandate is also to broadly protect the public's rights, and I think SB 1421 is also thinking about, when there is injury or death and use of force involved, that there's a greater public right to know and a greater standard of accountability that you might want to have, and therefore have more openness of the public records. So that's how I was looking at it.
Yes, and I believe that for purposes of what we do further with this matter, the cause question, I think, is what turns it for me. And I agree. This is not a situation where anyone has established that there was a single cause. There is, to some degree, there is this other cause. And so they're contributing causes, exactly the language that Member Stein used. And so we have to figure out how that is considered under the state statutes. And so, and I will say also to the complainant that, the different language is, to me, key. Direct result, and any type of I don't know what direct result is. It's not really a term that has it's not a term of art that I know about, but it does feel like we're talking about causation issue. And so any enlightenment on that, or any case law under the state statutes, might be helpful for this matter. So I think we ought to move it on.
I would agree.
Okay. I would make the simple motion that this matter be advanced onto the task force to be considered. That's it. Anything else you think I should add to that motion?
I think I would say that the records would seem to be public under 67.24D, which are records related to investigation, arrest, and other law enforcement, are public if no prosecution is sought.
Yeah.
But what's unclear is whether that exemption from SB 1421 should be applied or not, based on this issue of causation. I don't know if you want to get that there or not, but just to give a little more guidance when
Yeah.
the task force is reviewing the case.
Yeah, I think it is all about the exemptions here. Yeah. So, Ms. Lejay, what Member Stein said will be part of the motion.
Yes, that to consider the records are public under 6724D, which is related to direct enforcement. Am I correct?
I'm not sure about the last three words.
No. Just that I think that the records are public under 67.24D normally, and then the question is whether, well, I guess just leave it at that for now.
Whether these are records that are public and yet exempt under the
Under the SB 14.
under SB 1421. Okay. So when you're ready, Cheryl, if you've got that squared away.
You just want to look at 6724D and that these records are exempt under SB 1421.
But that's the matter for consideration.
I would say, and Government Code 6254 F.
Okay.
All right. So Dean, you are moving. Laura, you are second. To move to refer the matter to the task force for consideration, that the records are public under Administrative Code Section 6724D and Government Code 6254, and that these records are exempt under SB 1421.
You're saying that we're asking that to be considered. We're not saying they're exempt under 1421. We're saying that's the matter to be considered.
And that
they are public, but they may be exempt. So we are finding that they are public.
Public under 6724D.
I wouldn't say that it's that because is it D?
It is D.
I'm not sure if they're public only under 6254D. Are they?
6724D. Well, that's what I found when I went through it, that records related to investigation, arrest, or other law enforcement should be public if no prosecution is sought against the subject involved. Which is the case.
You're talking about under the Sunshine Ordinance.
Yes, under the Sunshine Ordinance.
Yeah. And I just want to say that they're also public under state law.
Okay.
Yeah. Yet, and Cheryl, this is just to clarify that you've got the note. Yet, what we're determining is whether they're exempt, and under Penal Code Section 832.7 and or Government Code 6254F.
54F. Okay. And what was the other citation I was typing? I'm sorry. I got my booster shot yesterday, so I'm a little slower today.
Okay. All right.
So I'm a little slower today.
The first one was Penal Code Section 832.7B. And the second one is Government Code 6254F.
Okay. Penal Code Section, what was that again?
832.7B.
Okay. Move that the matter be sent to the task force to be considered, that the records are public under Administrative Code Section 6724D, and to determine if they are exempt under Government Code 6254F and Penal Code Section 832.7B as a boy, and request that these records are also exempt under SB 1421.
Just one change, which is after 67.24 to say and state law.
Okay. Okay. So we want to open up the public comment now?
Yes, please.
This is public comment on the motion. Do we have any public
May I
comment?
party comment?
I'm sorry?
May a party comment?
Not on the motion, no.
Thank you.
This is public comment on the motion. Hello?
Anyone here for public comment? It does not appear so. Yeah, we would not have the parties comment during this period of time, Ms. Vice. Yeah.
Are we sure?
Okay, let's go ahead. Let's go ahead with the vote.
Are we sure our system is working? Because I feel like we've never not had public comment. Are we sure everything is working?
I'd like to make a request that if your microphone is on, please mute yourself, as we're getting a lot of background noise. Thank you. I'm sorry, Laura, you had a question?
Yeah, I just want to make sure everything is working, because it's just, we never don't have public comment, so I just wanted to make sure that there's no malfunction.
Two of our regular public commenters are on vacation.
Okay.
And just to note, this is Victor Young. All the members who are logged in, their microphones are active. No one is muted at this time.
Okay.
Okay. Yeah, but thanks for checking, everyone. Yeah. Okay, let's go ahead with the vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, second by Member Stein, that the matter be sent to the task force for consideration, that the records are public under 6724D and state law, and to determine if they are exempt under Government Code 6254F, as in Frank, and Penal Code Section 832.7B as in boy, and request that these records are also exempt under SB 1421.
Or whether they're exempt.
Mm-hmm.
Okay, we can move on to our third matter. We have 4 cases tonight.
Item number 6, file number 21115, Monica Price and the First Amendment Coalition against the Office of the District Attorney for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
Okay, I know Ms. Price is here. I believe so. And is there anyone here for the district on behalf of the District Attorney's Office?
Yeah, Robin Burke here from the District Attorney's Office.
Okay, great, thank you. So we will start with 5 minutes from the complainant when Cheryl's ready.
Ms. Price, are you ready?
Yes.
You may begin.
Okay. Hello again. So we also requested records regarding Mr. Clement's death from the San Francisco District Attorney's Office. We requested these records on August 3rd, 2021, and on August 16th, 2021, we received a generic response declining to provide records due to a backlog, and it had no date when records would be made available either. The district attorney's letter also encourages requesters to waive their rights to audio and video recordings because requests for these public records will increase their backlog. So I filed a complaint with this committee on September 3rd, 2021. And to be clear, I would like to inform the committee that this past Friday, October 15th, I was informed by the SFDA's office that some of the records related to Mr. Clement's death were released, and I was able to access these. But I believe this was an incomplete set of records. It also doesn't fix the delay to comply with the law in the San Francisco District Attorney's original response. So I do still have some concerns with their original response to decline records. The Sunshine Ordinance, Administrative Code 67.21 states that every person having custody of public records should make them available during normal business hours without unreasonable delay. The ordinance says that the custodian of records has 10 days to comply, and it took 74 days for the SFDA's office to partially comply with this request. This to me is just not sufficient. And as I stated before, Section 67.24 requires these records to be released once the district attorney determines there will be no prosecution. And they decided not to prosecute January 21st, 2021. So we're still about 9 months later, and we don't have all of the records released. This was some records, but I don't believe it was everything that the district attorney's office has. And there is case law supporting the requirement of a government agency to release everything they have, even if it was created by a different agency. In this case is Becerra versus Superior Court. So I have reviewed the records that were sent over on Friday. I guess my issue with these records is that while there are redactions, there's no corresponding reason for any of the redactions, and it's sometimes hard to tell what exemption or what law they're using as legal support to redact information. We don't I don't think have everything that they're in possession of. We don't have any body cam footage, audio or visual, and I get the impression that was reviewed by the SFDA's office in making a prosecution determination. So under Government Code Section 6254F, that's the section that requires the release of audio or video recordings related to a critical incident. And a critical incident is an incident when the use of force by a peace officer resulted in death or great bodily injury. Again, Mr. Clement's death would qualify because his cause of death includes law enforcement restraint. So we would really like to get the full record from the San Francisco District Attorney's Office. I would like to note, and I think the District Attorney's Office is in agreement, that Senate Bill 1421 does not have any exception for if someone is not prosecuted. It actually only allows delays while a district attorney's office is considering prosecution, but these delays must be justified. They need to have a specific reason for even just to delay the release of these records under Senate Bill 1421 regarding officer use of force. So I don't think there's no exception at all for, if there's no prosecution, then the records don't need to be released. I'm sure I don't need to remind the committee that it's very rare to actually have a prosecution of an officer. And if that were an exception, so few records would ever be released. But yes, I will be following up with the district attorney's office with our concerns, and we will continue from there. I think the biggest issue that I'm hoping this committee can help with is that the public should have access to these records. That access should be timely. And I would really love if it didn't require a visit to this committee. Thank you for your time.
Okay, thank you. Now we can hear from Ms. Burke.
Thank you so much.
Come on,
I
Ms.
guess we.
Just a second. So Cheryl needs to start a timer.
Yeah, Cheryl, I'll wait for you.
Thank you.
All right, Ms. Burke, are you ready?
I am.
Go ahead, ma'am.
Thank you. We do agree that 1421 records are public, and we make them public as quickly as we can. When 1421 was passed, you can imagine that we have quite a great deal of records to go back and redact. And therefore, with the advice of the city attorney, we crafted the response that we sent to Ms. Price. When records are requested, they get put in a queue and they're redacted as quickly as possible. And as we are working through all of those, when investigations are completed, the investigative file goes into a queue to be redacted by the investigator and the attorney on the case who reviewed the case. In the case of this, Mr. Clement, the case was indeed decided in January that that we would not move forward with charging, and it was redacted as quickly as possible when it was requested by Ms. Price. It is, to my knowledge, our full investigative file, but I look forward to her follow-up to see if there's anything else that we can provide.
Okay, thank you. We may have, this is time when we may have questions for the parties. I'll ask if Member Stein has any questions right off.
I don't have any questions.
Okay, thank you. I'm going to just ask for Ms. Burke, what have you been able to produce to the complainant?
Our full investigative file on the case. It's been redacted. There's a redaction key on our portal where we host all of our 1421 records. And, I'm not sure if the attorney put one up for this specific case, but there is a general redaction key. We were made aware by a previous complaint that we hadn't had a key up for these files prior to the previous complaint. And so we've been working on updating all of those as well. I will check in I'll take a look at the file to make sure that it did include the key for that particular file, but if it didn't, there is one that is a general key, and if there's not one for this file, I'll have the attorney pull it together.
Okay, yeah, you'll definitely want to double check and find out if there's no key yet. You definitely want to get that into place. Is there anything? You said that the full investigative file was produced.
Mm-hmm.
Is there any document or anything requested that was withheld other than redactions?
There are, not to my knowledge, but like Ms. Price mentioned, we have technical limitations on redacting and releasing audio and visual records. And so I would need to check in with the attorney to see if any of those were withheld, but I don't believe so in this case.
Okay, so you think that that's something that you're planning to check on is the audio visual records and the body cam? Okay, so that
when I look at the internal file, I don't see any of those in the internal file. which leads me to believe that they did not exist in this case. But as I said, when Ms. Price follows up, I'm assuming tomorrow we can have a conversation about what may or may not exist that we can work on figuring out a way to redact.
Okay, thank you. And just a question of Ms. Price. Just because you got a shipment of documents on Friday, could you describe just sort of give me a picture of like how many pages you got? Is this a massive file? Is it one page? Could you give me some general description of that?
Yeah, and excuse my estimation. I think it was maybe 200 pages top.
Okay.
Yeah, one part was a summary of the SFPD files, and there were a few still photographs taken from body camera footage, which led me to believe that there should be body camera footage somewhere.
Okay. And other than the video, audio video that might exist out there, that, you know, certainly possibly exists out there, did you get any indication that anything had not been yet produced to you other than redacted material?
I was thinking there may be transcripts from also the body camera footage. And I guess I wasn't sure that this would be everything that the San Francisco, I wasn't sure where between either the SF Police Department didn't send over their full file, because the first document in the file is kind of the San Francisco Police Department's self-created summary of kind of chronologically what was happening. And I wasn't sure if anything else was sent over from the San Francisco Police Department. So if you know, if there can be any confirmation, and I'll follow up with Robin about whether there was more that they have.
All right. And it sounds like you haven't gotten the redaction key yet. Is that correct?
No, I haven't, but I'll follow up with that.
Okay.
Can I ask?
Go ahead.
Sorry, can I ask something related to that? Because you said that you there was no reason for redactions given. Was there any notation around the redactions, or was it just blank?
Just blank black boxes.
Okay, yeah, because it wasn't clear whether there was some kind of information given but no key to it versus nothing was given. I mean, when we say redaction key, I'm assuming we're talking about how to interpret some kind of code of what was redacted. Okay, all right, thank you.
I would hope so. Yeah, they weren't labeled, but if a key had, you know, on this page, that's what it should be.
Okay.
All right. No further questions from me. I think we probably could now consider whether there's any reason not to send this on. What should we do here? Should we have a motion, etc.? Any thoughts?
Yeah, I mean, to me, again, it seems like these are public records and that this probably should be considered by the task force for a number of reasons, including the way the form letter is used, not having any redactions, much less a redaction key. I mean, not having any reason for redactions. Those are a couple of reasons in and of themselves.
Yes, I want to commend the parties for anything you can do to effectuate the, getting these documents out per, what the law requires. And it does, I want to say it does sound like both of you are working with each other, which is great. It does happen in every case, believe me. I think we do need to have the task force look at the question of delay here. I know that the DA's office is pressed for time, but we need to make a determination as to whether the passage of time in the big scheme of things still violates the ordinance. We may or may not be looking at redaction issues, and we also have the open issues of audiovisual and body cam. So I think that, please continue to work out any differences you have so that we can have as simple of a case before the task force as possible. And so that the law is satisfied. But I think we're probably going to need to go ahead and get this scheduled for the full task force to hear. So I made the last two motions. I should defer.
Okay. Then I guess I will make a motion that these records are public and this matter should go to the full task force, and maybe leave it at that for now.
Jurisdiction?
Oh, yeah. Well, we have jurisdiction. Yes.
Second.
Okay, so shall we go to public comment on the motion?
Yes, please.
Okay.
Is there anyone who wants to give public comment on this matter?
This is public comment on the motion to refer to the task force, that the records are public and that there is jurisdiction.
Well, it sounds like there's no public comment on this matter. So let's go ahead with a vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, second by Chair Schmidt, to refer the matter to the task force to find the records are public and that there is jurisdiction.
Okay, when you're ready, Cheryl, on to the next case.
Item number 7, file number 21005, complaint filed by Kevin Carroll, the Hotel Council of San Francisco, and Matthew C. Alvarez against Angela Cavijo, clerk of the Board of Supervisors, for allegedly violating Administrative Code Section 67.1, 67.7, by failing to provide fair and equitable access to members of the public. Board of Supervisors Budget and Finance hearing, June 25th, 2021.
All right, so this is a public comment matter. Is there, who do we have here today to speak on behalf of the complainant?
Good evening, this is Kevin Carroll with the Hotel Council.
Okay, great, thank you. And for the clerk of the board, who will speak?
Good evening. This is Wilson Ng, Deputy Director of Operations for the Office of the Clerk of the Board.
Okay, great.
On standby, I also have Elisa Samero, our Legislative Deputy Director as well.
Okay, good. Let's hear, we have 5 minutes for each side. Let's hear first from the complainant side. When Ms. Lejay indicates that she has her timer going, you can go ahead.
Mr. Carroll, are you speaking on behalf of the petitioner?
I am, yes.
All right, you may begin.
Good evening. My name is Kevin Carroll. I'm the President and CEO of the Hotel Council of San Francisco. We're a nonprofit trade association that represents the hotel industry. I've been attending and speaking at and organizing speakers at Board of Supervisor hearings for over 10 years. I do have the utmost respect for the clerk and her team. Neither myself or my organization has ever filed a sunshine complaint before. The complaint we're filing is involving the budget hearing on June 25th. Our complaint is not about having to wait to speak because we knew it was going to be a long day, but rather about the fact that the preferential treatment was given through non-public notification to community-based organizations that put our members at a disadvantage from when they were able to speak and also being able to bundle their speaking as well. These organizations were notified they could bundle speakers into videos and were also given instructions to call in earlier at 9 a.m. and the public was notified they could call in at 10 a.m. We would have really embraced the video component and pulling it together. In fact, our members, once they found out that this was happening while they were waiting online, they were coming at us as well as our other trade associations that we helped to organize to say, why didn't we know about this? And none of us did. We've not been able to find anywhere, nor has it been communicated to us, where the public was notified by the clerk that the option to bundle speakers into video, which we believe is a Sunshine Act violation. On page 131 of your packet, there are very detailed instructions that were made available to specific community-based organizations, but not made available to others. We have yet to see anywhere where this was publicly noticed. We had over 100 callers organized from our organizations and other trade associations that we coordinated with, and none of them were aware of this option either. Our first caller was not heard until 4.5 hours into the hearing, which put us at a significant disadvantage, and our members were understandably upset because they could have bundled their comments, and many of them had given up by this time after they had heard what was happening with the bundled comments. We have and always will follow instructions on how to provide public comments. As I mentioned before, I've sat through hours both in person and on the phone and have organized before, but the rules need to be fairly and equally communicated so that all organizations can follow them. We do not believe there was a full or fair notice to the public regarding this meeting. Again, it's not about the fact we had to wait, it's about the fact that preferential treatment was given to some organizations and not made available to others. And then I respectfully ask that you move this complaint to the full committee. Thank you so much.
All right, thank you. All right, for the responding clerk of the board, Mr. Ng.
Yes.
You may proceed when Cheryl gives you the cue.
Mr. Ng, are you ready?
Yes, I am. Thank you.
Go ahead, sir.
Good evening, members of the SOTF Complaint Committee. Wilson Ng, Deputy Director of Operations for the Office of the Clerk of the Board. As you may know, the Board of Supervisors meetings are scheduled on Tuesdays and attended to by the Clerk of the Board, Angela Calvillo. So unfortunately, because of the scheduling overlap, she will not be able to attend this meeting. But I have been asked by the clerk to stand in and provide opening remarks on behalf of our office. Elisa Samara, who is our Legislative Deputy Director, may also respond as well to any questions that the Complaint Committee members may have, as she is a department subject matter expert and our original respondent to the complainant. As you know, Public Comment Day for the Board's Budget and Appropriations Committee is an organized day every year to allow members of the public to weigh in on the annual budget considerations. And this year that occurred on June 25th. And every year we work really diligently to ensure equitable access in consideration of ADA accommodations, language accommodations in accordance with the Language Access Ordinance, and more recently in COVID times, digital divide accommodations for folks who don't have access to computers, phones, etc. And as well as consideration of the logistical needs that we need to minimize public wait times and ensure the availability of our interpreters. The community-based organizations or the nonprofit agencies that we work with and we organize with provide hubs to community members who may have these limited resources, whether it be ADA needs, language needs, remote access, or otherwise. And during in-person proceedings in past years prior to the state of emergency due to COVID-19, these organizations would come into the chamber in groups to provide their public comment. In a remote setting, we similarly provide them the opportunity to call in as a group, or the words we use is hubs, under one phone call. Part of that is because we need to identify them as callers in the system. And our office provided instructions in 4 different languages that were all publicly posted online under the budget information page for any community-based organizations with hubs that wish to call in, and for all public callers as well. The June 25th Budget and Appropriations Committee agenda directed people to view the budget information page on our website for more information on how to provide public comment. And on that webpage, in the large header text at the top of the budget instructions, were the guidance to organizations who are organizing these large groups. Videos were also previously submitted to us and were played when they came in line, or were done in lieu of verbal comments as they were in person. And we also didn't just play the video submitted, but they were also part of the public commenter's speaking time. Members of the public may similarly provide public comment during budget proceedings remotely as well, and may opt to use their allotted public comment time however they choose, whether it be a presentation or otherwise. And any members of the public may provide a presentation in lieu of speaking during the public comment time pursuant to the agenda's meeting procedures. It is on page 5, paragraph 3 of the agenda. I believe the agenda in your packet starts on page 112. Let's see, and on that under the agenda's meeting procedures, it states that members of the public who want a document displayed should provide in advance of the meeting to the clerk of the board, bos.legislation@sfgov.org. Clearly state such during testimony, and subsequently request the document be displayed or removed when they want the screen to return to live coverage of the meeting. So what folks would do is they provide materials in advance. And they would have to show up during the public comment period, announce a specific presentation or video to be shown, and then that cues our legislative clerks to display that image or video or audio or presentation. Even when we are in person, commenters are allowed to play videos, show slides or pictures, play audio, or even at times sing in lieu of regular verbal speaking. Remote meetings are no different in this case, but community-based organizations and members of the public must be present and on the line to request for that presentation to be displayed during the designated public comment period. This year we allotted 1 minute per person and adhered to that limit. We asked nonprofits who had hubs to call in groups of 10 to allow us to keep moving through the line, and most of them adhered to that limit. With the exception of individuals who required interpretation, which are allotted double the time, and all public commenters adhere to that 1 minute duration. Although certain interpreters, if interpretation takes longer than a minute, we usually provide a little bit of leeway, but not too much.
Mr. Ng, your time is up.
Okay, no problem.
Thank you. All right. So we may have some questions. And again, this is a complaint committee, and so we are determining how to handle this matter and what we may do next with the matter. I'll ask Member Stein to lead with any questions.
Yeah, hi, this is Member Stein. I guess I had a couple questions. One is for Mr. Carroll, is it?
Yeah.
The petitioning party.
Oh, sorry.
Yeah. So I think you're, you talk generally about some philosophical or democratic reasons why you believe the treatment should be more equitable, and you cited 67.1 violation of open meeting laws. I wondered, is there any more specific citations that you could point to in the Sunshine Ordinance that you believe were violated?
Well, we believe when we put it together that it violated the Sunshine Ordinance. I don't have the specific number, but the fair and equitable notice, the way that the Sunshine Ordinance is written is fair and equitable, and that is what we don't believe happened with this. I don't have any other specific numbers for you.
Okay, yeah, I was just checking. And then I also had.
Can you guys hear me? This is Matthew Alvarez. Can you guys hear me?
Oh, yeah.
Yeah.
Hi, I'm also a complainant. I'm sorry, I tried to speak up when you guys asked, but it wasn't working. I want to point to section 6.67.5 of the Sunshine Ordinance incorporates the entire Brown Act, and the Brown Act has specific requirements for notice and talks both in specifics and both in kind of high democratic principles of just the general notion of fair play and equal protection, right? And I think the representative from the clerk's office just admitted that they're treating people differently for reasons that existed pre-COVID when things were in person, and just for whatever reason has not thought that such accommodations are not necessary during a Zoom a virtual hearing type of situation. And so I think the incorporation of the entire Brown Act within the Sunshine Ordinance provides both the specifics violations that we think are here, as well as the general principles of, again, fairness and equal protection.
Okay, so Mr. Alvarez, just to confirm, your counsel, you're here acting as an attorney on behalf of the council, is that correct?
Well, I'm a complainant too.
You're also a complainant.
Just because we were following your guys' rules, so yes, I'm a complainant as well.
Okay, good. Yeah, I just wanted to clarify the rules here.
Sure. And I apologize. I tried to speak up when you guys called, but it wasn't unmuting me.
I see. Got it. Yeah, and that's fine. That's fine. Okay, Member Stein, back to you.
Yeah. So I just asked that because I was looking through the laws to look at specific things that were violated. I understand your position that you feel the spirit of these laws were violated, but I was also looking for specific citations. And then I have questions for the respondent, which is why do the CBOs need a different, or why is there a different protocol and process for the CBOs than for other organizations, including other nonprofit organizations? I mean, I know you alluded they might have members that are, have issues with translation and access, but other members of the public might have those issues as well. So why are the CBOs treated differently?
So, hi, Wilson Ng, Deputy Director of Operations for the Clerk of the Board. We also have Elisa Samira on the line who may chime in as well. But community, like when we address community-based organization or nonprofit, those instructions are applicable to any organization and not to any select group. The public comment presentation instructions are public information. We have a link on the agenda. We also have a dedicated website with public comment instructions for groups of 10 or more to accommodate larger groups. One of that is because these organizations represent individuals that require larger volume of language accommodations, or whether it be ADA accommodations or digital divide accommodations. That's one of the reasons. The other reason is because technologically, once public comment period starts on our system, we can't differentiate one group from another or one caller from another. We don't know which caller belonged to what group. All we see are anonymized numbers in callers in the order that they're received. When we reach out to or when we have the community-based organizations coordinate with us, that provides a little bit more coordination on our part, so that we can make the public comment process go a lot smoother. Absent of that process, it would be a free for all, and you would get repeat callers throughout the evening. Also, another one of the considerations that's really important on our end is the language accommodation piece. Because we have on-site interpreters that are available at a very specific time that are either salaried employees that are paid hourly, or we pay for outside interpretation, and those interpreters are there only for a limited amount of time. And this year, I believe we had Spanish and Chinese coverage until 7 o'clock. So it was imperative, knowing that some of these organizations had language access needs. We wanted to make sure that they had the opportunity to provide public comment while we had the interpreters on the line. And I'll also give the floor to my colleague Elisa Samir if she wants to add any additional comments, because she is our legislative deputy director and our subject matter expert when it comes to legislation and the process.
Thank you, Wilson. This is Elisa Samir, the Legislative Deputy Director. Wilson is absolutely correct with his statements, and I just want to make it clear that we are not giving preferential treatment to certain community-based organizations. The reason for these directions or these instructions is guidance for these organizations who will already be organizing their people. This was our chance to let them know that if they do organize these groups, we're asking them to only organize them 10 at a time, so that we do get these regular callers, so that we're not getting just one hub calling in and then taking up the time for 20 or 30 callers, whoever they've organized.
So,
go ahead. Yeah.
Oh yeah, so I'm trying to understand, because when I looked at the two different sets of instructions, one clearly labeled that it was for the CBOs. That had sort of a different set of instructions than what seemed to be for the general public. So where is the general public told that they can also organize these hubs of 10 if they want to handle their presentation that way?
Well, anybody, if they called in and they had a hub, we would, because we do that even during our regular public comment periods. There are lines that call in and they have several people who are on that phone call. And so we do take them, and they'll say, I'm speaking, but I have 3 other people in my household that would like to talk. And then we take them as they go. And it's the same for any kind of videos, documents, or any submissions that anyone wants to show during a meeting. They can, and there's instructions on every board agenda or a committee agenda that lets people know they can submit documents ahead of time, like they would if they were in the chamber, to show. They would normally, like if it was in person, they would be showing it on the projector, and then we would show it up on the screens. But during these remote times, obviously people were not in person, so we do need those things ahead of time. And so it was our way of trying to get them organized so that everybody is sending it to one place. We had an idea of how many people were calling in, but it was not limited to certain organizations at all. We called it the community-based organizations instructions because we understood those CBOs are the ones that are organizing the hubs. They're the ones that are going out and getting people who may not have the resources to maybe log in online or access the meeting, and so they were organizing their people, and so we were trying to make sure it's efficiently done so that they don't have the expectation that they're going to call in and have an endless amount of people providing public comment. We asked them that if they could keep it down to 10 minutes, and if they do provide videos or documents in lieu of their speaking, that they provided them to us ahead of time so that we could vet them, because obviously public comment day is where we have a extremely high volume of these things occurring, but it's something that we normally do for every single one of our meetings. We have boarding committee meetings every day, and we always have submissions for people who are calling in. We just had one at the board where somebody was looking for a video that they wanted to play for in lieu of their speaking comments.
Then can I also kick this question back to Mr. Carroll, I guess. Were you aware that these hubs existed and that you could have 10 people present in a...
Thank you for asking me. Absolutely not. I've looked at the meeting notices. It says call in at 10 o'clock. I've never seen it, and none of the trade associations I work with, and we have many of them, had heard of this before at all. I've sat through public hearings where people may come in a group and speak, and I've been on other calls, but I'd never seen this happen. And frankly, it was 4.5 hours before any non-hub person was called on, before an individual was called on. I was even texting the supervisor, Matt Haney, to ask him, because I was like, when is this going to stop, these hubs? And we would have loved to have done it. It would have made it easier for everybody, but we had no awareness of this at all. So thank you for asking me, because we would have done it if we had known about it.
Okay. And I guess I have one more question for the respondents, which is that when I read the public, the sort of terms of participation for the general members of the public, it talked about there being a 2-minute limit, and for the community hubs, it gave each participant a 1-minute limit, but then aggregated into 10. Is that correct? Is that your understanding of the sort of participation procedures?
I think,
presented?
yeah, I believe the general remote instructions for public comment, I think it generally says 2 minutes because that's what's normally given. But for general public comment day, as you know, the chair of anybody, they can determine how long public comment they want to assign between 1 to 3 minutes. It can be anywhere between 1 to 3 minutes. 2 is obviously the standard, but for general public comment day, the chair had took it down to 1 minute.
Oh, so everybody
had 1 minute. Yeah, everybody did. Yeah, everybody did.
That I didn't see that in the documents that I reviewed. Okay. All right. Those are my questions.
Yeah, and then the 10-minute aggregated time was it was our setting, giving them, the CBOs in these hubs, some kind of guidance, some kind of, parameter, so that we didn't have, endless amounts of people that they expected to talk all at one time.
Okay.
I have just, this is Chair Schmidt, just a couple of questions here. I think we're possibly going to be looking at this again, so I don't want to take too much extraneous time. But I'll start with Mr. Carroll, or actually, let me ask Mr. Alvarez if you're there. Have you, other than in your written materials you've submitted, have you identified any specific legal, either state or local laws that you feel are violated here?
Yeah, this is Matthew Alvarez. So no, we can't point to a specific provision where it says that if the board, if the clerk of the board is going to set up separate rules for different types of people, they've got to put it all on the same agenda. But I don't think, the Sunshine Ordinance law itself and the Brown Act are not written in that way.
Okay.
They defer to the agencies and the departments themselves to come up with, fair agendizing of and public comments. That's up to them. And so the issue here is not so much, this, whether you want to call it the spirit or the letter of the law being broken. I would say both have been broken because similarly situated people and groups were treated differently. And that is a violation of the Brown Act. That is a violation of the Sunshine Ordinance Act. I appreciate you guys are trying to, get to a specific provision, that details how, particular, meetings have to be agendized and noticed and all that kind of stuff. But that's just not how the Brown Act or the Sunshine Ordinance works.
When you say treated differently, is there anything here that would support that other than the claim that they were made to speak later in the day as opposed to earlier in the day?
Sure, and that's a huge advantage. When you have a meeting that goes 9-10 hours, the people who got to speak first are the people who are remembered. That is, that's true. But people were treated differently by how the agenda came out. Only if you knew you were a community-based organization, which the public doesn't know that they can become that. only if you knew where in the, where online you could find that, did you have the ability to, pull your work together, get videos and other, visual aids, and then present earlier. So our point is not only were we treated differently at the meeting, but we were treated differently in terms of how this whole thing was agendized and publicly noticed.
Okay. And next to Mr. Carroll, when you, were you, okay, the document that is at the top of the document, the one that says community organizations, is that the document that you claim you weren't made aware of? Or were you believing that because it's titled that way, it didn't apply to you?
No, that's the document we weren't aware of and found out about later. Yeah, and
And you were looking for guidance, and you looked around where you thought any guidance would be, and that document did not appear anywhere there. Is that your claim?
That's correct.
Okay.
We looked at the meeting. There's no reference to that document on the meeting notice at all that we can find.
All right. At what time? Oh, Member Stein has a question.
This is very related. I just wondered if the document that you saw or the information that you saw, because the only other piece I have, I think in this packet that speaks to what guidance was given to sort of the general public is on P133 or sort of P134 actually, in the respondents packet, which says, which is remote meeting call-in. Is that the instruction you saw? And I asked this too because that under item 8 says you have standard 2 minutes to provide your comment. It doesn't mention that you only have 1 minute. So I'm just wondering, I don't think we have in our packet what it is that you saw, or is this what you saw?
Well, I'm scanning through it now. 134. What we saw was the regular meeting notice for the meeting. So let's see if there's two different notices.
Did you believe that you had? And did you believe you had 2 minutes or 1 minute to speak?
Oh, we always plan for 2, but know that we can be cut to 1 minute, and that happens a lot. And usually at the very beginning, like I was at the beginning listening, and as soon as I think the Supervisor Haney said if speakers will have 1 minute, then I let my group know they only have 1 minute. So that's we were thinking we'd have 2, but we were well aware that it could be cut to 1. And because that happens.
So then you probably did see an instruction that gave the standard 2.
Yeah, we saw the regular instruction that said how to call in. I'm looking for it in this packet, but it was, what the meeting ID number is.
So P133 is P133 is remote meeting call-in instructions, providing public comment instructions, and then P134 has that item 8. You have 2 minutes.
Yeah, I'm looking for it. 134. For some reason, remote call-in instructions. Yeah, I'm used to the one that has the clerk's name at the top. Yeah, public comment is this. Watch it on channel this, channel 2678. All of that with the meeting ID is what we would normally see. Yeah.
Okay.
And then we always, like I mentioned, we know, we hope it's 2, but it's quite often it is cut to 1, and we're prepared. We prepare our groups for that too.
Okay, thank you. Sorry to jump in. It was a follow-up.
That's all right.
I appreciate it.
Yeah, if I may though, this is Elisa again. For for general public comment day, it's not a regular, it's not a regular day for us. So there's a special page for the public comment instructions.
Is that still up somewhere that we can?
Yeah, I can share it on my screen if you'd like me to show it to you right now.
And we can't see the screen. I didn't.
Yeah. It's still on the website.
I don't know if we'd be able to we have people on the telephone, so I don't know if it's going to be proper to have documents that not everyone at the hearing here can look at.
All right. Well, the public comment webpage is still up under Supervisor Haney's budget information, and under where it has the documents to show where you could provide public comment by email. There, it still has it up right now.
Okay.
And if I may chime in, this is Wilson again. On your agenda packet, page 113, on the up in the top first paragraph, sfbos.org/budget information. That website link is still live with all the contents.
Okay,
contained.
thanks. Thank you.
Great.
Member Stein, I've got a question queued up. Okay. All right. To the representatives of the clerk, the document that has been set forth, which talks about procedures for community-based organizations. The complainant said that was not available to them. Can you tell me if there's some reason why you disagree with that? It was
Yeah, it is something, like I said, we published it on the website in 4 different languages to ensure that we were able to meet the widest audience possible. It is like, if you look on the public comment page, it is in the biggest font on the page.
Okay.
So, it was not something we were trying to hide, and even the regular public comment link for the regular instructions is much smaller underneath it, and then there's another live link for people to provide public comment via email also. So because it was, because that is something a little bit out of the ordinary for that day, because we have such high interest of groups coming in for this one particular day, we do put it up there large so that people are aware of it.
Now, you have 2 sets of instructions. One is general public and one is community-based organizations. The community-based organizations instructions talk about the hub concept, correct? That
yes.
instructions?
Yes.
Okay. The general public comment document, does it talk about hub instructions?
No, that links.
Okay.
Back
it doesn't. It doesn't.
Public,
all right.
Yeah, regular public.
So if somebody's not a community-based organization, they're probably going to feel like they need to go to the instructions under general public comment, and so let me give me a minute here. You don't have another page that's available to other nonprofits that don't consider themselves community-based organizations. Is that correct?
No, we didn't. We don't break it down that way.
Okay.
Yeah,
okay.
no, we just. Yeah, no.
Okay, and you had said earlier that people are organizations that are not considering themselves community-based organizations would be free to use the same procedures for hubs that are listed on that document, correct?
Yes.
Definitely. Okay, but you don't have anything that says on that document, even if you're not a community-based organization, you can use this procedure, correct?
On the regular public comment page?
No.
Yeah.
On the document that talks that has at the top community-based organization, you don't have any text on that document that says that non-community-based organizations may also use those hub procedures that are described on that document, right?
Elisa, I can respond.
Yeah. Okay.
Well, first, let me just define the definition of a hub. Hub just essentially means that there'll be the organizations are going to be dialing it from one number. So if members of the public can convene a large enough group and they all dial in one number, as Elisa mentioned earlier in her presentation, they can introduce themselves and say, hey, we're dialing in from one number. We have 10 individuals who will all be individually providing the public comment, or alternatively, they can say they have 10 people and we're collectively providing a public comment. On the agenda for members of the public, under on the agenda page that starts on page 112, under the budget. Sorry, give me 1 second here. Under there are instructions for members of the public who would like to submit documents to the clerk of the board in advance. They can contact our office and provide any meeting materials they'd like displayed.
Okay,
but
there's no hub option, right?
Well, they can. I mean, if they want to convene additional parties to call in by one line, they can certainly follow those same procedures. But there's nothing prohibiting them from like procedurally submitting documentation to the clerk of the board or organizing a group to call in from one number in advance.
Okay. All right. I don't think I need to ask any more questions. Member Stein.
I don't have any more questions either.
Okay. Thank you, everyone. I think it's time for us to deliberate on what to do here. Yeah, I mean, I think we're going to need to have the whole task force look at this. I do think that on the one hand, I'm not sure if I would find and we're not deciding the case, but we're just talking about it a little bit. I don't know if I'd find a violation just in the fact that certain people had to give their comments later in the day as opposed to earlier. I know that that's probably realistically your effect is going to be stronger at the early part of the day. Although there's different rules for different people, different rules for different organizations, and if there's two sets of rules and one of the sets of rules has at the top of it community-based organizations, I think a reasonable person would think, I can't follow those rules if they don't consider themselves a community-based organization. So it seems like we've got some factual questions as to whether we may have some type of unfairness here.
Yeah, so I did comb through the Sunshine Ordinance and the Brown Act looking for discussions or mention of equitability and fairness. And it's a little bit, I understand it's like spirit of the law, but I was also kind of looking for letter of the law. And the one thing that I was problematic for me about having these two different sets of instruction, although I realized something different happened when people went into the meetings, was the idea of time limits being applied uniformly, because it seems like you have one set of instructions saying you have 2 minutes, you have another set of instructions saying you can bring in 10 different people and have sort of 10 minutes in aggregate, 1 minute each. Mm-hmm. And so that was one I was wondering about. That's Sunshine Ordinance 67.15C, that time limits shall be applied uniformly to members of the public. Although I understand, so that was, to me, like a sort of maybe the one section that seemed like it maybe needed to be looked at. But otherwise it's kind of a little bit of a gray zone. But clearly there are two different sets of instructions that, again, I agree with you on this kind of reasonableness question. Like a reasonable person would say, well, I'm not a community-based organization. I'm a nonprofit trade association. I can't do this thing. And then if you look at the actual public comment call-in instructions, I mean, I understand, yes, there's that line about they may participate by phone or submit their comments by email, but that's not the same as saying, oh, you can represent yourself by video, up to 10 members, 1 minute each, or, you know, it's a very different level of instruction that doesn't give the same level of specificity and potentially the same level of access to, you know, different categories of the public.
Yeah, and I would say that, you know, we may be talking about section 67.15 when we get to the full task force. And I don't know, you know, I have no idea what I would think in terms of whether there's a violation of the law here. It seems like the clerk of the board they have a pretty tough job in trying to organize tons of people to come in with all kinds of different kinds of requirements, et cetera. And if everyone gets a chance to give public comment, I'm not sure if what we're seeing here is a violation of the law. However, it's not our job today to decide the case, so I prefer not to really render my own personal decision here today. So I think basically, I think that I'm going to move that we do send this to the full task force to look at. I believe we do have jurisdiction to possibly consider whether there is a violation. And it's, you know, it is a public meeting, and so that's my motion. Although I'm going to just make a notation for Mr. Carroll and Mr. Alvarez, which is, I know you've brought in due process and fundamental fairness arguments, which I think I probably would, if I were in your shoes, I'd probably make the same argument. I don't know though if that's a basis where our task force could make a decision. Generally, the laws that are dealt with are the Sunshine Law and state law, the Brown Act, the FRCP. I'm not saying that we couldn't find a due process violation. I'm saying that it's unclear to me whether we could. So that's not a part of my motion. That's just a notation to you for future, you know, action. Okay, so that's my motion.
I'll second it.
Cheryl, that pretty simple motion. What'd you get there?
Moved by Chair Schmidt, second by Member Stein, to send the matter to the full task force for review. That there is jurisdiction, and this is a public meeting decision. Am I getting it right?
Public meeting. I don't know if decision would be a word that's part of it. You can knock that word out, and that's the motion. Yes. So when you're ready, Ms. Leger, we can move to public comment.
Just a second. This is public comment on the motion. This is the opportunity for public commenters to make a public comment. Do we have any speakers? Public comment on the motion? I'm sorry, Chair Schmidt, you want to say something?
No, it doesn't sound like we have public comment on this either. Very unusual meeting in that way, but Well, I guess that can happen. So let's go ahead and vote.
Chair Schmidt,
Aye.
Chair Schmidt, aye. Member Stein,
Aye.
Member Stein, aye. Moved by Chair Schmidt, second by Member Stein, to send the matter to the full task force for review, that there is jurisdiction and that this is a public meeting matter.
So whenever you're ready, Cheryl, looks like we can move to the next item.
Item number 8, announcements, comments, questions, and future agenda items by members of the complaint committee.
Well, I do know that I will say that we're scheduling a future agenda item that is developed and created by Member Stein. And I know that's in the works, and it looks like it may be either done or very, very close to done.
Yeah, I'll just say I'd like that to be on the agenda for the next meeting.
Yeah.
And I just.
Yeah, complaint committee or task force, complaint committee, okay.
Oh, for complaint committee.
Yeah.
Complaint committee.
Yeah, I know.
Yeah,
I
complaint committee. Just I want to just make clear, I know that the final of that would need to be ready by a certain date. I may want, I'm looking at it, and so I may want to, I may have certain comments, but I know that it's in draft, and it looks really good. Go ahead.
Yeah, this is something I'm not 100% clear on. Ideally, when would you receive an item for the next meeting? I presumably not on Friday. So how many days early would you want to have that item?
It would be Friday, I upload the agenda. Mm-hmm. Thursday is the day I compile all the materials and get them ready for the packet. So let me just tell you what that date would be right now as I look at a calendar. So it looks, let's see. Well, that's, I would say by November 18th, because third will be the task force.
Can you repeat that date?
November 3rd is the task force. Okay. Complaint EOT meets on the 9th. So for the complaint committee, you would have to get your materials to me by November 11.
Okay. All right.
Yeah. Just do it before 5 o'clock. The next day, I mean, if I get it like first thing in the morning when I get to work, I can insert it and get it prepared for the agenda, but it has to be first thing.
Okay. Thanks for letting me know. It's like mystery. All right. Thank you.
I think it seems to me that it's going to be pretty close, if not exactly what has already been developed. But yeah, I know, but that gives some time for any kind of tweaking that needs to be done.
If we have a question though,
yeah.
Would you want Chair Wolf to participate in that hearing so that he can hear your ideas and provide comment before it goes to the task force? I can ask him
if he would like. That is completely fine. Yeah.
Okay.
Or any other third member, because I think that, he would be good, but any other member too, if there's a third member, because it's really trying to be as polished as we can be before we take it to the task force.
Mm-hmm.
Yeah, any member is they can line up and they can all be involved. That's fine. Yeah.
Yeah, I'm sorry, I don't really mean polished, but I mean input. The more input, the more members who have looked at it and like in our committee and said, okay, we agree or we don't agree, or this is what we would do, and then take it forward, I'd be happy to have another person.
And also, I mean, it's just gonna be something that comes out of the committee, so it's something that people would see anyways. I know we only have 2 committee members now, and so there may be someone else sitting in. I don't know.
Yeah.
I don't have anything else. Member
I
Scott.
don't either.
Okay.
No.
Yeah, and I may have one of these agenda items, but I'm going to wait till we deal with that. So that would be in the future. I've been just thinking through some of the weird questions that we've come up with regards to the processes that we're supposed to be effecting in this committee, and also I'm trying to figure out if I can come up with an idea that would maybe be generated into a proposal to deal with the backlog, but that is not up yet, so that's simply a future potential agenda item. All right, so I think that's all for number 8.
All right, next item.
Yeah.
Item number 9, adjournment. I have 8:03.
Good. Move to adjourn.
And Laura seconds.
Oh, second it.
Okay, let me stop the recording.